this month, October 17th, it became legal to purchase and grow small quantities of marijuana in Ontario. You know, the thought of purchasing a home that has been used to grow marijuana may cause some emotional response for some buyers. So it's important to understand whether this is a concern for you as a buyer or a seller. Appropriate steps need to be taken to protect your interests. So how do you handle a sale involving a home that has some plants grown within it? You know, if you're a seller, you must understand the difference between something that must be disclosed versus something that may be disclosed. Your real estate agent role is to understand and explain the issue and to assist you to insist you on making a very informed decision. Just because cannabis is illegal does not impact the law when it comes to disclosure. To understand what needs to be disclosed, it's important to remember the difference between stigma that's related to the home's past and physical defect that is in the property. So, stigma is a non-physical part of a property that may trigger a negative emotion. You know, however, the events that trigger these emotions is not an actual function or appearance of the property. For example, a home that was previously occupied by a serial killer, or a home where suicide had happened. What facts that may affect a buyer, of course, would depend on the buyer. For example, one buyer may believe a home where a single marijuana plant was legally grown is a concern, while another buyer may have no concern whatsoever. So in Ontario, there's no requirements on a seller to disclose the existing fact that may be a stigma to buyers. So if you're a buyer that have concerns regarding different type of stigma, it's important to let your agent know so that your agent can ask the important questions and find out if there are issues. So a defect, on the other hand, is something physical affecting the property. Now, physical defect falls actually into two categories. First is the patent defect, where it's visible or can be identified during a home inspection. That, of course, doesn't involve making holes into structures. For example, if there are water stains on the wall or water stains on the ceiling, there is no requirement actually for sellers to disclose these kind of defects. Latent defects are things that may not be easily found, even by a home inspector or other expert. If the latent defect poses a serious risk to the health and safety for those who live in the home, it must be disclosed by the seller. For example, latent defects such as structural problem that can be dangerous to occupy the property, or damages to the utility system that makes it a risk to live in the home. It's important to understand the difference between patent and latent defects as it applies to growing marijuana. Having plants inside a home may not necessarily cause physical damage to a property. If there's no physical damage, or if there was some damage and it has been fully remediated and therefore free of any defects, the home's history still has potential cause for stigma, if of course it's a concern for the buyer. If you're buying a home, you must be open and clear with your agents about the thoughts about a home that had marijuana plants. So buyers, you actually must be really clear with your agent that you do not want to buy a home that was used to grow marijuana. So if you do not want such homes, your agent can actually do several things. One, they can do something as simple as ask the listing agent. Or two, do an online search and obtain any other public records regarding this property. Many cities or police services actually maintain a record of residence that was used to grow marijuana illegally. However, this kind of research only uncovers, major grow-ups, and they may not have records of the small scale grows, where they have only a few plants. Actually, third, your agent may include in your offer, a seller warranty that the home was not used to grow marijuana. Typically, for obvious reasons, of course, these types of warranties should only cover the period the seller owns the property and, of course, occupied it. Depending on the language of the contract provision, if the seller refuses to agree with the warranty, it may indicate the property was used as a marijuana grow up, or it may simply mean that the seller doesn't know what went on in the property before they bought it. In either case, you'll need to talk about this further with your agent. As a seller, your agent should talk to you about the trade-off of proactively disclosing the home's history to potential buyers, keeping in mind that a seller may not know what happened in their home before they own it. You know, a buyer's sale representative or buyer's agent may also specifically ask whether the home has ever been used to grow marijuana. In this case, there are two options. You may either answer truthfully or decline to answer the question and direct the buyers to conduct their own research. The choice of these options lies exclusively with the seller. So that's some of the information there is in regarding the legalization of marijuana. Remember, although it's legal, it doesn't affect the rules around disclosure. Hope this helped, and I'll see you next time.